She also noted that Clayton's expert's testimony narrowly defined pregnancy as requiring a pregnancy diagnosed by ultrasonographic visualization of one or more gestational sacs, which is totally fucking unreasonable. What's up, everybody? Welcome back to the internet, where your cesspool is my jacuzzi. My name is Lauren Nighty, and due to my current lighting situation, I have a very shiny forehead. If you're like me and you don't love reading through long documents, I'm here to kind of summarize this morning's orders entered by the court in the Clayton Echard Laura Owens paternity scandal case. The court received and considered Clayton's amended motion for relief from judgment based on fraud, which was filed in April. The initial motion for relief had been filed in March, seeking to set aside the order of protection that Commissioner Duty granted to Laura. Commissioner Duty, who in my opinion lived up to his name during those proceedings, granted the order of protection based on allegations that Clayton had basically cyberbullied Laura by allegedly posting her alleged sonogram with alleged twins. Laura admitted to doctoring that sonogram. The decision made by Commissioner Duty was based on a fraudulent sonogram. Clayton filed the amended motion after he became aware of an appointment that Laura had at MomDoc on November 14th, 2023 for a procedure that was not related to pregnancy. Clayton is seeking to have the court 1. Dismiss the order of protection, 2. Grant leave to submit a China Doll affidavit, 3. To award Clayton attorney's fees, and 4. To order further relief as the court deems just, including a pending consequence to the current outstanding sanction request by counsel for the petitioner. Clayton asserts that Laura committed fraud by altering the sonogram. Laura asserts that the contents of the sonogram are real and that she only altered it by changing the name of the provider, and she added her name to it. She alleges that she got the ultrasound anonymously at Planned Parenthood in Mission Viejo. She changed it to say that it came from Southwest Medical Imaging. However, neither one of those facilities has any record of her getting an ultrasound there. She claims to have changed the information on the sonogram to prevent Clayton from harassing the provider and harassing her. Which is interesting, coming from someone who is constantly blocked and creating a million fucking phone numbers to reach out to the guy. Respondent asserts that plaintiff committed extrinsic fraud upon the court in procuring the OOP as evidenced by the plaintiff's testification that she had a miscarriage in September before she filed for an OOP, while representing herself as pregnant with defendant's twins in the ex parte filing, which occurred in October. Respondent separately asserts that plaintiff committed both intrinsic and extrinsic fraud when 1. She testified that she sent both a member of the media and Clayton a photo of the sonogram, but that only Clayton could have posted the copy of the sonogram, and 2. Plaintiff testified that the sonogram had not yet been published online when she alleged that Clayton published the image of the sonogram. However, she had already published the sonogram online through a publicly accessible Dropbox. And 3. Plaintiff testified that she sent defendant the ultrasound photo and ultrasound video when no ultrasound records exist. So Clayton is saying that the order of protection should be set aside because Commissioner Duty based his decision on a fraudulent sonogram. Laura is asserting that the order of protection was granted not just based on the sonogram. Setting the sonogram aside, she's saying that it was based on Clayton's allegedly harassing text messages. Laura disputes the claim that she was never pregnant, as we know. She's citing her expert testimony from Dr. Medchill, who claimed that she was pregnant with 99+% certainty based on 5 HCGs showing positive. Dr. Medchill, who, to my knowledge, never saw Laura. Laura is also claiming that even if she was never pregnant by Clayton, the OOP should still be valid because they had a relationship that was formerly romantic or sexual in nature. She also noted that Clayton's expert's testimony narrowly defined pregnancy as requiring a pregnancy diagnosed by ultrasonographic visualization of one or more gestational sacs, which is totally fucking unreasonable. This also mentions the medical records where Laura allegedly was diagnosed with real ovarian cancer and not something that just may be there, and from her reported ovary removal surgery and surgical abortion. So Clayton is requesting relief because of all this fraud, saying that the fraud was the basis for the order of protection. Laura is arguing that, no, this wasn't the only reason it was granted. He sent some mean texts to me at my 13th Google phone number. Commissioner Duty is quoted here. He said, "The way you publish this photo, it's unflattering. That's my reason for making my decision." Clayton alleges, in addition to the admittedly doctored sonogram, there was also the sonogram dated September 5th that Laura claims was faked by one of her prior alleged victims and was sent by Laura to both Clayton and Steve Carboni. Is it Carbone? Carboni? I don't know. He's Reality Steve. This one was identical to a publicly accessible video that was online from years ago. And 3, the sonogram that was sent from Laura's email on October 12, 2023, that was sent to the media with her commentary. Clayton is asserting that Laura and David are acting contrary to court order by posting their filings online on Twitter. I will not call it X, that is a stupid name. Clayton also asserts that the expert testimony referred to by Laura is not credible, given Laura did not disclose the medical records from 2016 referred to above to Dr. Medgill, which may have affected his statements about the likelihood of her pregnancy based on HCG pregnancy tests. Clayton repeats his request for a setting aside of the OOP and attorney's fees. Next, the court received and considered the petitioner's emergency motion to strike and request for immediate telephonic scheduling conference. Laura filed this motion largely on the basis that Clayton's reply in the amended motion for relief raised new matters rather than only responding to matters raised in the response. Specifically, the petitioner notes that for the first time, the respondent brought up the 2016 medical records of the petitioner for the first time in the reply, thereby raising a new issue. 2, the respondent alleged that the petitioner concealed information from her medical expert related to the 2016 medical records. 3, the respondent alleged that the petitioner fabricated 3 ultrasounds. Additionally, the petitioner filed this motion asking for an immediate telephonic scheduling conference to discuss whether or not the respondent will be permitted to call several untimely disclosed witnesses. Clayton asserts the petitioner's motion to strike did not conform to Rule 29C and that the disclosed material was timely. The medical records were properly disclosed to the petitioner in a timely manner. The new material, including the petitioner's medical records, is not new to the petitioner. So essentially they're saying that the information raised in the reply was not new or untimely. Laura disputes and swears in an affidavit that basically she's saying that the records of her ovarian cancer and surgery were fake records, that she never had cancer, never had an ovary removed. She provided records to Dr. Medgill that confirmed she had both ovaries, and she did not disclose the existence of a prior ovarian cancer diagnosis because that diagnosis never happened. So she's essentially saying, like, no, I didn't have cancer, but I'm totally not the one who pretended I did. Next, the court received and considered the petitioner's motion in limine. Okay, so Laura is essentially she's trying to stop her I don't even want to call them ex-boyfriends because I don't feel like that's what they really were in most cases, to exclude her ex-somethings from testifying against her, saying that the substance of their testimony was not disclosed, trying to argue that some of it is inadmissible because it is evidence of other wrongs and that none of the exceptions to this rule apply. Clayton asserts that Rule 404b(2) expressly permits the testimony of the 3 witnesses. The respondent also asserts that disclosure of the intent of the respondent to call these witnesses was timely. The disclosure occurred March 29, 2024, and the deadline was May 10, 2024. Clayton's side also asserts that oral argument is unnecessary. I'm not going to read too much more of this. It's basically like kind of a Hail Mary pass saying, like, please don't let my client's ex-boyfriends testify against her. Okay, so now to the orders. It is ordered the amended motion for relief from judgment based on fraud is granted in part, denied in part. The court will join the OOP with the current trial on the outstanding issues. The parties previously granted the court permission to observe the order against harassment hearing for purposes of ascertaining any award of attorney's fees or sanctionable actions. The court will also review Commissioner Duty's order of protection hearing and will rule on the validity of the order of protection, and any award of attorney's fees at the trial on June 10th to determine if the order of protection should be affirmed or invalidated. It is further ordered the emergency motion to strike and request for immediate telephonic scheduling conference filed April 30th is denied. It is further ordered the motion in limine filed April 30th is denied. And it is further ordered the request for oral argument is denied. So, if you want the TLDR, basically, Laura batted 0 for 3 on this one. I don't know if I did a very good job of narrowing that down, but hopefully this helped. If not, well, that doesn't really bother me. You're the one listening to me talk, so bye.